Now your bill, SB 1149, our number 7.
Excellent. Thank you very much. Well, hello, Mr. Chair and members again. I want to first thank the committee staff for their work with my office on this very important bill. Thank you very much. I will also be taking author's amendments as described on page 10 of the committee analysis.
Thank you.
Before I begin, please consider this question as I present this bill. If it had been shown in court that the coffee you were drinking now or earlier this morning was contaminated with toxic chemicals, wouldn't you want to know that? Sadly, in many instances, that happens often related to defective products and environmental hazards due to courthouse secrecy, and the public oftentimes doesn't even find out until years later when many people have already been injured or even died. Senate Bill 1149, also known as the Public Right to Know Act, would prohibit factual information about dangerous public hazards from being hidden from the public through overly broad court protective orders and agreements to keep information about dangers a secret. In open society, court records are presumptively open to public inspection. Even in a dispute between private parties, a court's resolution of that dispute is a matter of public interest. This is especially true when a case involves a public danger, such as a defective product or environmental hazard. But courts repeatedly issue overbroad protective orders that keep discovery information secret and protect incriminating documents, and lawyers mutually agree to settlements and stipulated orders that prohibit disclosing the very facts that even prompted the case. Secrecy is sometimes necessary to protect personal information or legitimate trade secrets, but is grossly inappropriate when it clearly keeps information about ongoing dangers from the public. In very real way, it can threaten their health, safety, and even their lives. If signed, California would join several other states that have enacted similar anti-secrecy laws, including Florida, Louisiana, Montana, South Carolina, and Washington. Witnesses with me today will share exactly why this bill is critical, but I will just mention a couple of the quick examples to highlight the need for SB 1149. In the case of Purdue Pharma, the company told outright lies for many years regarding the safe dosage levels and likelihood of addiction from OxyContin, which ultimately killed hundreds of thousands of people. These tragedies that touched far too many families across California and the nation was largely enabled through courthouse secrecy and the very tactics that this bill seeks to address. In the case of Cooper Tires, the company kept information secret regarding the tires not meeting industry standard safety features and keeping belts from separating. In the 2 decades before 2017, there were at least 362 deaths, 49 in California alone, and several dozen more people with paralysis, brain injuries, and other serious injuries like the loss of a limb. Everything related to these defective tire dangers was shielded from public scrutiny for over 20 years, 2 full decades. My office and the bill sponsors have shared with each of your offices a dangerous incidents list. The spreadsheet details these and many other examples of courthouse secrecy that have injured and taken the lives of far too many Californians. Members, so that no other family ever again has to bury their loved one as a result of this unacceptable courthouse secrecy, I hope you will support 1149 today. I have 2 witnesses with me today that will speak on the need and the importance of SB 1149, the Public Right to Know Act. Richard Zitrin, Professor Emeritus at UC Hastings, appearing on the behalf of Public Justice, and Lori Andrus, who served in leadership to the Ensure litigation coordinated in Alameda County Superior Court. And I believe they're both calling in, Mr. Chair.
Thank you. I do have them both listed as here on the telephone. Professor Zitrin, are you with us?
Yes, I am, Chair Stone. Can you hear me?
Yes, go ahead, please.
Okay, great. Thank you. Chair Stone and members of the committee, this is an issue I've been working on for a long time because of my background in legal ethics. It is simply wrong for lawyers or judges to be complicit in keeping things secret where the public dies as a result, as Senator Leyva described. Over 12 judges over the period of 15 years entered protective orders to keep information that was revealed about OxyContin secret in those court proceedings. In the case of Cooper Tires, there was a joint coordinated proceeding in front of one judge in L.A. County who kept hundreds of thousands of documents secret. That case has now been settled, but the documents are still secret. In the case of Esure, Lori Andrus, who's going to speak after me, will talk about her experience, but I do want to mention a couple of things. Bayer kept the company that bought Esure kept the defects secret for 12 years. There were 67,000 complaints made by women to the FDA about the harm that had been done them, and ultimately 27,000 lawsuits. All those lawsuits were consolidated in a case in Alameda County that issued a protective order. The protective order allowed, as most of these protective orders do, allowed the defendant to self-select what items could be confidential. And in the case of the protective order there, Bayer self-selected 97.7% of all of the 900,000 documents in this case to be confidential, when it should have been limited only to those things that are corporate proprietary information and trade secrets. And it took the plaintiff's lawyers' motion to deal with individual cases of 200 documents one at a time in order to release those documents. They succeeded, but the time it took for them to release those documents, plus the fact that their duty is to their individual clients, is something that shouldn't be a burden on the plaintiffs or their lawyers. It should be a matter of law. Everything after the case still remains secret except for those approximately 200 documents. 1149 is a big change in the law. There's no question about it, but it is necessary to save lives, and it will continue to protect corporate proprietary information and trade secrets. You have our response from Public Justice as to the opposition, which is going to speak after me. I will remain on the line for more questions, if anyone has any.
Thank you. And we'll now move to Lori Andrus.
Hi there. Thank you, Mr. Chair. Yes, my name is Lori Andrus, and I am testifying today on behalf of the Consumer Attorneys of California. Thank you also to Public Justice for inviting me to speak in support of SB 1149. For 20 years, I have represented people injured by dangerous pharmaceuticals and flawed medical devices. I represented dozens of women who were implanted with the Assure birth control device. My clients, along with thousands of other women, brought civil lawsuits in California's courts beginning in 2015, and they alleged the following. These devices were marketed to women who had already had a family and were done having children. The devices were billed as safer and less intrusive than having a tubal ligation surgery, which is commonly referred to, of course, as having your tubes tied. The devices consisted of two small metal coils, one to be placed in each fallopian tube. The devices were designed to cause inflammation and to prompt scar tissue to form around the coils in the woman's abdomen, thus blocking sperm from reaching her ovaries. The women who filed suit alleged multiple problems with these devices. The devices could break, they could perforate the fallopian tube, they could migrate around the abdomen, they could puncture and become lodged in nearby organs. They could also result in ectopic pregnancies. An ectopic pregnancy is where the fertilized egg grows outside of the uterus. That can cause the death of the mother. It's a terrible event, and it should be avoided. Terrible pain at the site was another common effect that these women alleged in their lawsuits, and also pain during intercourse. They alleged skin rashes, likely due to the nickel that was a component in the coils. Roughly 5% of the population is allergic to nickel. Many of these women also documented heavy bleeding, some said like a horror movie, and severe cramping in an unusual and abnormal aspect. To remove these devices, my clients and these other women had to undergo partial or total hysterectomies. Many of these women were in their early 30s when they began to experience menopause after these premature hysterectomies. I encourage the committee members to vote yes on SB 1149, and I'm happy to answer any questions. Thank you.
All right, thank you. So is there anyone in the hearing room who would like to indicate support for SB 1149? We'll not take further testimony, but just give us your name, your affiliation, and support.
Mariko Yoshihara on behalf of the California Employment Lawyers Association in support.
Eduardo Martinez with the California Labor Federation in support.
Thank you. Anyone else in support? All right, seeing none, operator, would you go to the lines and see if anyone would like to indicate support for SB 1149? Again, no further testimony, just name, affiliation, and support.
Thank you, Mr. Chair. If you are in support of SB 1149, please press 10 at this time. Line 35, you are open.
Good morning, Mr. Chair and members. This is Assembly Judiciary calling on behalf of public health advocates in support.
Next is line 46. Please go ahead.
Hi, this is Sandra Cushion on behalf of CalPIRG calling in support.
Line 105, please go ahead.
This is Santiago Rodriguez with California Environmental Voters in support.
Line 68, you are open.
This is Michael Brooks with the Center for Auto Safety in strong support of SB 1149.
Please go ahead, 83.
Jason Solomon, Stanford Center on the Legal Profession, strong supporter of the bill.
Line 18, you are up.
Hi, Oriane Shin, Policy Council of Consumer Reports, also co-sponsor of SB 1149 and strong support. Thank you.
Line 107, please go ahead. And as a final reminder, please press 10 for anybody in support for SB 1149. 107, you are open.
Good morning, everyone. Kip Muller here, civil rights attorney, board member with the Consumer Attorneys of California, in strong support of this bill as well. Thank you.
Mr. Chair, there's nobody else queued up at this time.
All right, thank you, operator. We will now move to opposition. I have one opposition witness listed, Chris McKaylee, here with us in the room. Looks like there are two opposition witnesses. Come forward, please.
Hi there. Jamie Huff with CJAC. Sorry if I... Thank you. Am I okay to go?
Go ahead.
Give me that one. Thank you. Good morning, Mr. Chair, members. Jamie Huff on behalf of the Civil Justice Association of California. While we appreciate Senator Leyva and have nothing respect for what she wants to do, we have problems outlined with this bill. Under SB 1149, any information concerning an alleged defective product or environmental hazard, whether or not the information is relevant to the action, is presumed public at both the settlement stage and also, and most importantly, through the discovery stage. This bill would make any company doing business in California at risk, excuse me, at risk of losing valuable proprietary information, making it available to their competitors, regardless of whether there's any merit to the suit. A defective product or environmental hazard doesn't exist simply because the lawsuit is filed saying it does. The functional impact of the bill would be to release confidential information prior to the information ever being presented or substantiated in court. We could see businesses put in a position of settling frivolous claims to avoid the dissemination of proprietary information, or encouraging more of those settlements outside of the watchful eye of the court where there's actually accountability. We could also see courts bogged down with a lot of hearings to determine the confidentiality of each piece of discovery, which, as the lawyers know, there is a ton, particularly in defective product and environmental hazard cases. Protective orders are very common in litigation, and it allows parties to freely share information in order to review and determine the relevance of their cases without the fear of dissemination to the public. This is, in today's system, if there is something that merits public release, you can go ahead and petition the court to do so, and the judge can disseminate that information. For individuals and companies and industries in California that rely on research and development in particular, their trade secrets are the lifeblood of their companies, and the two-part test in this bill is a very high level. It would be very hard to keep trade secrets confidential, significantly higher than the good cause shown standard used in courts today. So for the following reasons, we are respectfully opposed to the bill. Thank you.
Thank you.
Good morning, Mr. Chair and members. Chris McKaylee on behalf of California Business and Industry Alliance. CABI is opposed primarily due to the ambiguity, in addition to the comments made by CJAC, the ambiguity in the language, and I think that's particularly exacerbated by the fact that in subdivision F of the proposed new CCP section, any person who's not a litigant or is not a party to the litigation can challenge. And in subdivision H, there is language that would allow state bar action against an attorney in certain specified circumstances. So we think that will cause even bigger problems. What are some examples? If you look at the language, if I can burden you to look at page 4 of the bill, which is in section 3, the first terminology is defective product or environmental hazard. They use the same words to define themselves. In other words, it says defective product or environmental hazard means a defective product or environmental hazard, blah, blah, blah. So I looked elsewhere in the statutes. The term defective product is used in one single statute in California, undefined. So neither the bill nor other statutes give us a definition. The bill, when introduced, had the term environmental condition in it. That was viewed as too large, or too broad a definition. So it was changed to environmental hazard. Nonetheless, the bill contains no definition of environmental hazard either. However, that term is used in 20 other state statutes, none of which provide a clear definition, but in the B&P code, it does give examples, including asbestos, lead paint, and radon gas as examples of environmental hazard. Again, I think there's going to be tremendous litigation over what falls into this. I would raise the following query. Some of the examples, including that of OxyContin, would they even fall under the parameters of this bill? It's my understanding that, for example, in that case, that litigation is the claim is a basis of deceptive advertising or deceptive marketing as opposed to a defective product. If you look at the settlement language in subdivision B at the bottom of page 4 and top of 5, it reads that it applies to agreements between the parties to restrict the disclosure of factual information related to the action. Query, what does purport mean? Does it mean allege or to claim? Those are terms that we use elsewhere, but that's not here. What do we mean by restrict? Do we mean limit? Do we need ban? Do we mean to ban or actually prohibit? What does restrict mean? Factual information, when is that proved and to whom? A judge or a jury? How about related to the action? Often we use things like directly related or reasonably related. What does related to the actual action actually mean? And on the exemption language in subdivision D that Ms. Huff referred to, there are only 4 narrow exceptions to the presumption that all of this factual information be publicly available. Medical info or PII, the settlement amount, citizenship standard status, and then the third one under D3 is proprietary customer lists, very narrow, or trade secret. And what was alluded.
I need you to wrap up, please.
Oh, sure. And very briefly on that last item, it's a very high burden contained in D3 Cap B, clearly outweighed by specific and substantial overriding confidentiality interests. The litigators with whom I have spoken about that language believe that that is a very high, if not impossible, standard to meet. Therefore, it's giveth with one hand the exception and taketh with the other with that high burden. Thank you, Mr. Chairman.
Thank you. All right, is there anyone else in the hearing room who would like to indicate opposition to SB 1149? Again, we'll not take further testimony, but name, affiliation, and opposition.
Good morning, Mr. Chair, members. Ashley Hoffman on behalf of the California Chamber of Commerce in opposition. Thank you.
Good morning, Mr. Chair and members. Moira Top here on behalf of both the Orange County Business Council and Biocom California in opposition.
Mr. Chair and members, Laura Fitzgerald on behalf of California Life Sciences in respectful opposition. Thank you.
Thank you. Anyone else? All right, seeing none, operator, would you open the lines for anyone who would like to indicate opposition to SB 1149? Again, we'll take name, affiliation, and opposition.
Mr. Chair, if you are in opposition to SB 1149, please press 10 at this time. 10 to testify in opposition to SB 1149. Line 94, you are open.
Mr. Chair and members, Mark Smith on behalf of the National Marine Manufacturers Association in opposition for the reasons previously mentioned. Thank you.
Next is line 91. Please go ahead.
Good morning. Taylor Roshan with the California Farm Bureau in opposition.
103, you are open.
Good morning, members. Lily Mosesian with the California Manufacturers and Technology Association in opposition to SB 1149. Thank you.
And we'll go to line 73.
Good morning, Mr. Chair and members. Victoria Rodriguez on behalf of the Alliance for Automotive Innovation in opposition.
As a final reminder, please press 10 for opposition to SB 1149. Line 63, you are up.
Good morning, Chair and members. Fabiano Ordina on behalf of Western States Petroleum Association in opposition.
Line 40, please go ahead.
Chair and members of the committee, Matthew Allen with Western Growers, also opposed.
And Mr. Chair, we have exhausted the queue.
All right, thank you, operator. You may close the lines, and I'll bring it back to the committee. Questions, comments? Ms. Reyes.
Thank you, Mr. Chair. In reading through the opposition and hearing the comments, one of the things that, of course, is important for any business is, as is noted, legitimate trade secrets. I will tell you that I sincerely appreciated the response from Public Justice regarding each of those items. And I think that what's important, as I understand, it is disclosure of factual information as opposed to allegations. Is that correct?
Correct.
And on the definition that was in determining definitions of what it is that can or cannot be disclosed, I would imagine that during litigation, this is something that would be part of a resolution to define certain items?
Yes, correct.
All right. Thank you.
Thank you.
Thank you, Senator.
Thank you. Other comments, questions? All right, seeing none. Senator, I want to thank you for bringing this forward. We've gone through this before, unfortunately not very successfully. And it's interesting listening to the opposition, because what the case that they really want to make is that the consumer protection laws are there to compensate for injury, which means that they're not a deterrent and they're not preventative of injuries. That is just inhumane.
Yes.
And just an astonishing interpretation of the body of consumer protection law. And what your bill really does is sunshine defects so that they can be dealt with, not in 10 years, 15 years, 20 years while people get injured, but get dealt with immediately, because consumers are then informed of the danger and can make informed choices when they're in their market. We are a market-based system. It's also interesting, the opposition seems to kind of gloss over the fact that much of the consumer protection laws in California are common law. They're judge-made laws. So I think the courts know how to handle definitions, know how to handle and interpret what we do and from this committee standpoint, the way that you've crafted this law, I think meets an appropriate standard for how courts then could adjudicate what is before them and deal with confidential information. And it's just astonishing to me to think of defects and environmental hazards being considered trade secrets. None of the companies I have ever worked for would have considered such as trade secrets, but yet in this context, the whole current way that the opposition want to construct the consumer protection law would mean that defects are part of someone's trade secrets. That is kind of astonishing to me. So I appreciate the effort here, and I wish you the best. And with that, you may may close.
Thank you very much, Mr. Chair. I appreciate all the work you have previously done in this area. And I think astonishing is the right word. When this bill was, I had the opportunity to carry this bill, I too was astonished that some of these things were hidden and there was a secrecy around these defective products and people were maimed or died. I would just say that the opposition talks about trade secrets and intellectual property. The legislation specifically recognizes the need to protect trade secrets, and this is not, as you even noted, what this bill is about. The opposition also talks about a lot of what ifs. I think they try to confuse everyone with their what ifs. I will leave you with one what if. What if it was your family? What if it was your loved one who was maimed or injured by one of these defective products? And then I would also just ask everyone to please review. The opposition didn't seem to like the Purdue Pharma OxyContin example. That's okay. There's so many other defective products that have maimed and killed people. So we can look at these. Mr. Chair, again, thank you for your work in this area. Thank you for your support, and I respectfully ask for an aye vote.
Thank you.